Please be seated. We're ready to hear argument in 21-130, State versus Volkswagen, and 21-133, State versus Audi. Justice Blacklock and Justice Young are not participating in the decision of the case. The governor, pursuant to statute, has designated Chief Justice Sudderth of the Second Court of Appeals and Justice Jaime Tijerina of the 13th Court of Appeals to sit in place of Justice Blacklock and Justice Young, respectively. Justice Lehrman cannot be present this morning, but expects to participate in the decision of the case.
May it please the court. Mr. Stone will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. This court has consistently upheld the exercise of personal jurisdiction over defendants who engage in additional conduct beyond introducing a harmful product into Texas. It is consistently stated that either advertising in Texas or creating, controlling, or employing a distribution chain that brings a harmful product into Texas is sufficient additional conduct. And it is consistently acknowledged that jurisdictionally relevant additional conduct may come from either a defendant's own actions or the actions of an intermediary. The German respondents have committed such additional conduct. As this record shows, they ordered their intermediaries to advertise to Texans, and they controlled the message sent. The German respondents created and controlled the distribution system that brought their illegal software into Texas for installation on the property of Texans. And they ordered, monitored, paid for, and profited from that installation, all to advance their massive criminal fraud. Whatever else may be difficult about this case, that additional conduct is enough to establish personal jurisdiction here. Now, I'd like to start with how the conduct of the German respondents fits well within the outer guideposts of this court's and the United States Supreme Court's holdings regarding additional conduct sufficient to establish personal jurisdiction.
Let me ask you this. You quote Spur Star in a number of occasions relating to the indirect conduct that led to VW America to conduct the recall, correct? But it's been suggested that VWA didn't know the true nature of the software. Is that correct?
To the extent that that's something that they're taking a position on, Your Honor, it's a factual dispute that's currently being litigated in the court below. And to the extent the court thinks it a relevant fact, all facts have to be construed in favor of.
But if it was, if they didn't know the true nature, then wouldn't it be more of a direct contact from the German respondents or the German defendants with the vehicles in Texas?
I suppose so, Your Honor. To the extent that, as a matter of fact, and in the record, the record contains a statement from Stuart Johnson, Volkswagen of America corporate representative, describing themselves as a pass-through entity vis-a-vis the software. To the extent that the German respondents would know that Volkswagen of America was unaware of the contents and had no ability to monitor those contents, then it would seem to shift that towards a direct contact. But here, given that this was taking place in a recall chain where the German respondents had full control over the process, everything from declaring the need for a recall to manufacturing the software to distributing it, directing its installation, the instructions for its installation, everything down the chain, I think whether it's considered a direct contact or an indirect contact for purposes of this court's decision in Luciano is sort of almost metaphysical. I think in both eventualities, it would be perfectly fair to charge that conduct against the German respondents for jurisdictional purposes. So again, this court's case law clearly indicates that, for example, advertising to Texans is a sufficient contact. It's not merely one of, as described in Asahi, the 6 kinds of additional conduct that are sufficient for establishing personal jurisdiction. It's sufficient unto itself. Here, the German respondents ordered, controlled the language of, partially drafted and ultimately approved the advertising of their illegal software to roughly 29,000 to 30,000 Texan owners of affected cars. Those individuals came in and had the cars installed pursuant to the German respondents' instructions, which the software arrived into Texas using a proprietary system, first a server mechanism, and then ultimately being downloaded into the Otis terminals, of which the German respondents were aware. They actually inquired with Volkswagen of America before uploading the software as to all the dealerships at which this software is going to be physically transferred. They were informed by Volkswagen of America of 60 dealerships in Texas that this software is going to physically enter and be used at. And then they uploaded the software using the controlling, employing, or creating or controlling that distribution system for that software to physically enter into Texas, where it was used tens of thousands of times. Past all of that, of course, the German respondents, as shown in this record, monitored the installation of that software, reimbursed the installation of that software, and of course, sort of the pinnacle point here, they of course benefited from the ongoing evasion of the detection of their, beginning in 2006, massive environmental criminal fraud. That was, of course, the core purpose, that and averting ongoing recall or ongoing warranty costs behind the software in the first place. So for purposes of this court's evaluation of whether or not the German respondents have purposefully availed themselves to gain some profit or some benefit in Texas, this plainly falls within not just the outer bounds.
I don't think that those facts are disputed, but they counter with, hey, we just did it to the United States. And so because we sent everything to Volkswagen America and it was supposed to just go across the United States and it was their job to do that, then you can't impute jurisdiction on us. How do you counter that?
I think that's more of a legal characterization, Your Honor, but if it is a fact, once of all, if it's a fact, then it's a disputed fact, which again, this court from Luciana beforehand has to construe to the extent there's a dispute, which of course there is.
Do you agree that Volkswagen America took delivery of the vehicles in Virginia and assumed responsibility for warranting their fitness and compliance with state law?
Yes, Your Honor, but the claims here arise from the tampering software, not the original distribution of the vehicles. So for purposes of personal jurisdiction, the existence of the vehicles in Texas is taken as a given. They've already arrived here, they've been purchased here, facts of which, again, the German respondents were aware. So when they say that they were trying to target the United States, recall from Nicastro, even on its own terms, Nicastro describes this situation as one where perhaps a putative defendant has created a relationship with the United States government and with no state, which it calls that potentiality extraordinary in its own terms. This is not a circumstance where, for example, the German respondents sold products only for use in federal enclaves or only to the federal government, where there really would be a true availment only of the United States government, the United States as a regime. Instead, they engaged in conduct, putatively at least, in all 50 states, though that isn't clear from this record. And of course, the response is, well, because personal jurisdiction might be appropriate in other places, it can't be appropriate in Texas. Well, this court's already dispatched that argument at least twice. First of all, expressly in Luciano, where the court said to a Connecticut distributor, and foreign is foreign for purposes of personal jurisdiction, be it Connecticut or Germany, saying to a foreign distributor, the existence of your personal jurisdictional contacts elsewhere does not negate or lessen the propriety of exercising personal jurisdiction here in Texas. And then secondly, the other place where the German respondents rely on this specifically targeting concept, which I understand they're sort of using as a form of differentiation, comes from Spearstar, where the distributor in Spearstar, again, this court cited Asahi for purposes of additional conduct. The distributor in Spearstar wasn't merely a distributor in Texas. It was a distributor for Texas and all of North America. That appears in the court's opinion several times. So to the extent that distribution to the entire United States somehow affects the jurisdictional analysis, this court in Spearstar said that that sales agent in Texas was a sufficient agency contact for the state, a sufficient, not a necessary one, and the fact that it distributed elsewhere in North America did not change the analysis.
Right, and that certainly works for Volkswagen America, but I think the difference is that Volkswagen America was the national distributor here.
Respectfully, Your Honor, it worked in Spearstar for the foreign manufacturer. the employment of Limited, Spearstar Limited, the limited corporation that was the intermediary distributor, the fact that that entity was used as a sales agent within Texas and North America, all of North America, did not diminish the fact that that contact was relevant for Texas jurisdiction. So this isn't merely, Spearstar wasn't merely a case against that intermediary distributor. It was attempting to discern what the foreign manufacturer had done. And the employment of that agent, an agent that acted both in Texas and elsewhere, did not change the fact the agent acted in Texas.
The fact that they simultaneously affected vehicles in other states as well as Texas seems more relevant to me to the question of fortuity with regard to Texas. So there's case law that say the defendant has to have targeted the state, not merely the person who fortuitously happened to be in the state, or the thing, not the state, not merely the thing that happened to be in the state. And there's a sense in which the fact that some cars were in Texas, the fact that a lot of cars were in other states helps to emphasize the fact that some happened to be in Texas. They weren't targeting Texas. They merely were targeting cars, some of which fortuitously happened to be in Texas, others in other states. What's your response to that relevance of the other states?
So when this court's discussed fortuity, it's usually included the other antonyms from purposeful, which is to say accidental or isolated. I think understanding fortuity is easiest combining them all into those sort of that bucket of similar concepts. And they all have in common the idea that there could be a one-off, like in the Castro 1 or up to 4 machines that arrived somewhere with neither knowledge or any appreciation of what was going to happen. Here, of course, there was not only purposeful availment in the sense of that they knew tens of thousands of cars were in Texas before they uploaded the software or advertised. They appreciated and monitored that ongoing conduct and reimbursed it. It can't be said to be accidental if, in order to continue a nationwide plan of covering up a massive environmental fraud.
Isn't it true that, looking at this record as a whole, it doesn't matter to VW Germany and Audi Germany if the cars were in Texas or Oklahoma. The cars is what they wanted to affect.
Perhaps not, Your Honor, but this court in Moncrief has already said their subjective intent, their subjective motivations are irrelevant. The question is their objectively verifiable business contacts with the state. Those objectively verifiable contacts included, aside from putting aside their knowledge, that as a matter of fact, they controlled the dissemination of the software into 60 locations, ordered its installation tens of thousands of times, advertised it to even more tens of thousands of Texans, reimbursed it, and profited from it. All of those were with full knowledge to the extent that this court's considering whether something's fortuitous or knowing or fortuitous or foreseeable, all with full knowledge of the existence of those vehicles and the effects in Texas. I mean, for purposes of really putting a pin on the difference between...
Why couldn't we just ascribe that to happenstance, though, right? They would have done the very same thing regardless of where the cars were, regardless of whether any of those cars had been in Texas. And isn't that how this case is different from Spearstar, where the foreign entity sent executives to Texas to tap into the Texas energy market? That's missing here.
But in Spearstar, Your Honor, again, the executives hired a local distributor or a local intermediary sales agent that also was responsible for all of North America. There's nothing in Spearstar that suggested that was differentiated except for the presence of local offices, to be clear, which is a different kind of additional conduct, that can lead to personal jurisdiction. But the idea that they undertook these actions elsewhere, and this court's rejected that in Luciano to begin with. And more to the point, it would have been impossible for them to continue with their goal, which is to say, concealing this environmental fraud, if they simply had abjured tens of thousands of cars into which they identified by VIN number and knew were in Texas, if they abjured installing the software here. It would not have been possible. Volkswagen AG is essentially saying, we intended the United States, we didn't intend the states. They're not permitted to sort of say, well, we're going to reject the idea of dual sovereignty, of a system of dual sovereignty in between a federal and state sovereign. They have to take that as a given. And when they have to take it as a given, they're responsible for the actions they've objectively taken in Texas. Remember, this is not a circumstance where they directed a tort, as this court has distinguished finally, directing a tort at just a Texan. The tort they committed here was against the environment of Texas itself, the literal air, water, and ground that comprises Texas as an entity. If there's a case for a deliberate tort being justifying, as this court put in Guardian Royal, sort of provides greater substantiality to otherwise insufficient minimum contacts, which we think are here anyway, or
So do you think the same argument would work if they'd only sold 100 cars in a state?
I certainly think.
Much smaller state.
I certainly think that would be a different case. I think to the extent you still have the distribution and advertising, that's probably still enough additional conduct. The volume, as the U.S. Supreme Court put in Hustler, and as this court has put in Moki Mac, the volume is certainly relevant, right? To the extent you have tens of thousands of sales on an ongoing basis, it's very hard to think of that business as fortuitous or accidental. And there are, of course, tens of thousands of sales here by the German respondents controlled. In the intermediary context, there's a much less degree of control for the sales.
But it seems like it might be the argument that the distributor would want to build sales in every state, and the foreign manufacturer would say, we don't care, all we're aiming at is North America. We don't care about the states. That's up to you to decide.
Well, in this record, there's a statement by, I believe it's Niels Fisher, who acknowledged that it probably would have been impossible for the distributor here to have actually accomplished their maximizing market opportunities without availing itself of Texas, the second largest market for these. So whether that might be the case in terms of a smaller market with fewer and more remote sales, Texas is essentially a G9 power economy. It's impossible to imagine they ignored Texas. And again, to the extent there's some dispute about Volkswagen's corporate knowledge, this court, again, Luciano and countless cases beforehand, construes all factual disputes in favor of the denial of the special appearance at the trial court level. If there are no further questions, I'm happy to cede the balance.
Any other questions? Thank you, General. We'll hear from the respondents.
May it please the court. Mr. Wall will present argument for the respondents.
Mr. Chief Justice, and may it please the court, we all agree on the legal standard here. The question is whether these German corporations targeted Texas.
I've got a question. How do you counter the state's argument that this was an environmental tort committed against the state of Texas?
So it wasn't an environmental tort directed against the state of Texas within the meaning of the Supreme Court's or this court's cases, Justice Sudderth. It was an environmental tort that occurred throughout the United States. It was addressed by the federal sovereign to the tune of more than $1 billion, 209 million of which went to Texas. And I want to be clear, that wasn't just for the original installation of the defeat devices. The EPA's notice of violation also covered the tampering. That was part of the settlement with the United States, the $1.3 billion. And Texas and its residents received over $200 million to remediate the environment. So I think we've addressed it under the legal rules in exactly the right way. The federal sovereign attacked national conduct. The German respondents have been sued in other states where they had different contacts, like California and Virginia. And the simple point is just they aren't subject to jurisdiction here. That doesn't mean they aren't in other states.
But is it your argument that only the federal government has concern about Texas environmental quality?
No, it's not that Texas doesn't have a concern, Justice Sudderth. It's that the jurisdictional analysis under the Due Process Clause has multiple prongs, and one is fair play and substantial justice. We're not here challenging that, because the state obviously has a regulatory interest. But there's a separate prong on purposeful availment that focuses not on the plaintiff's interests, but on the defendant's contacts with the forum state. And what this court has said and what the Supreme Court has said, and the state agrees in its briefs on the standard, is that the German companies needed to have targeted Texas. So as the court said, you've got to have sort of a Sahi plus. Now, there are lots of different ways
Why do we have to have a Sahi plus if this is not a stream of commerce case, given that the cars are already here?
Because it is a stream of commerce case in the following sense, Justice Busby, which is the cars are already here, right?
The stream brought them here, but your clients knew that.
That's right, but the same argument, by the way, was made to this court in TV Azteca, it was made in Luciano, it was made in Spearstar, right? Everybody knew that the TV broadcasts were coming into Texas. Everybody knew that the spray foam was already here. Once you hit the first sale, by the time of the second sale, you always know that the stream is coming into the state. And the argument always is, well, it isn't just that you sold it into the state. By the second sale, you knew it was there and you continued to sell. And the court said,
it's not
not
just
enough.
that they continued to sell, they modified it while it was here.
But I think the point, though, is, Justice Busby, that selling into this, it doesn't matter what you put into the sentence. They sent cars into the state or they sent software into the state, right? You could do either one. They transferred the cars in Europe, they uploaded the software in Europe. Either way, VW America took the cars and brought them into Texas, took the software and brought it into Texas.
But it was brought into Texas on a distribution channel that VW Germany maintained and controlled, and if I understand the record correctly, it was also installed on Texas cars using a proprietary system that was provided by VW Germany, but located here in Texas.
So there's a lot there, and I want to unpack it, Justice Busby, because I don't think that that's what happened. So 2 months ago, the state moved for summary judgment against VW America, the original defendant here, which has never contested personal jurisdiction. In the state's words in that motion, VW America, quote, arranged, managed, promoted, advertised, and directed the recalls at Texas dealerships, end quote. Then this past Friday, the state filed its summary judgment reply. In that brief, the state again takes the position that VW America, quote, directed the installation of the software at Texas dealerships. I can't square those statements with General Stone's opening. I think the state is right in the trial court and wrong here, which is to say, once the cars and the software were handed over to VW America at a national level, had nothing to do with Texas, VW America controlled dealing with the dealers and the customers with respect to the recalls.
But isn't it VW Germany and VW or Audi Germany that are paying the cost of those repairs?
On a national basis, they reimbursed VW America. So what happened was VW America paid the dealerships, and then it had a total bill for the entire country, and that was paid by VW Germany on a national basis. Nothing to do with Texas. And just to come back to your question, Justice Busby, on the Otis system, it forms a page of a deposition. It's barely mentioned in the state's briefs below. It's barely mentioned in their briefs here. It didn't factor at all into the Court of Appeals, very thorough discussion. And the reason is that as far as we know, it's no different from the software. It was developed by VW Germany, but as far as we know, overseas, handed over to VW America. And there's nothing in the record to show that VW Germany played any role in the installation or maintenance of that program at the dealership level. The state never asked.
But it's their system, according to the record.
Oh, they developed that system just like they developed the software. But if they developed that system abroad, as we believe they did, and they handed it off abroad, we have no reason to believe any differently, it's not any different from the software update. It doesn't add anything to, I mean, certainly, I'll say, and I think it's undisputed, VW Germany developed the software update and uploaded it to a mirror server in Europe. If that's enough to trigger personal jurisdiction here, that will be true for every aftermarket update or recall. And the state conceded that the last time it was here. The Chief Justice asked, is there any difference between Montana and Texas? And the state correctly said, no. The theory applies to all 50 states. And
Well, not if a key piece of that is the proprietary equipment in the state that actually modifies the product.
Well, but again, the proprietary system was developed abroad by a foreign corporation. It was then installed, as far as we know, there's nothing in the record suggesting VW Germany played any role in the United States. So it would all still be VW America conduct. If you can charge...
What if it's the dealership's conduct?
Well, it's just a system that resides at the dealerships.
Right, and
we
the
don't know-
contract here gives VW Germany direct control over the dealerships for purposes of managing this recall.
I don't think that's right, Justice Busby. That's not in the record, and that's not correct. VW Germany did retain the power to order the recall because it's required to do so by federal law. As a condition of selling cars in the country, federal law requires that it conduct a recall if federal authorities want one ordered. But it didn't direct the recall. The recall was directed, as the state has now told the trial court twice, including in a brief filed this past Friday, that the recall was directed by VW America, and that's what the facts in the record show. VW Germany handed over, and the Court of Appeals was absolutely right about this. Its decision is crystal clear on this point. VW Germany developed the software and wrote a technical description of what the software was and handed it over to VW America. VW America took the technical description, inserted it in the letters, sent those letters out to the dealers and customers, and worked with the dealers and the customers on the recall.
You keep saying handed over, but didn't they just drop the software through the chute, if you will, all the way down to the individual dealers.
I don't think that's quite right.
Well, then what control did VW America have over it?
Well, so VW America, as far as we know from the record, maintains the servers here, the mirror servers here in the United States, not located in Texas. So VW Germany develops the software, uploads it to a mirror server in Germany, and then that's the end of VW Germany's involvement. It syncs to a mirror server here in the United States. We don't know whether it's pushed out or pulled through. I can talk about that. I don't think the facts are helpful to the state, but they're not in the record. And then at the dealer level, when a dealer goes and hooks up a car, it's pulled down from the mirror server through the system and downloaded onto the car. That's conduct done by VW America and by the dealers, not by the German corporations. All they did was provide the software update, and they did it overseas. And I do
designed the channel all the way through, including their technology in Texas.
Well, but Justice Busby, I want to stop for just a minute and take a step, because no court, as far as I can tell, has ever found personal jurisdiction based on undifferentiated conduct across the 50 states. Admar, the Fifth Circuit, Dijmoos, the Third Circuit, Thornton, the Northern District of Alabama, in a car company recall case,
But
all rejected the notion.
Why would that be relevant if we say we can't look at the subjective intent of the defendant?
I think the reason it's relevant, Justice Busby, is what the state wants you to do, and I understand it's a fairly attractive plaintiff here, but it wants you to move the law on personal jurisdiction to a place that, as far as I can tell, no federal or state court has gone. And it will not just mean that you subject foreign corporations to personal jurisdiction. It will mean you subject everybody down to the smallest businesses in Texas. Imagine a startup company here in Austin that develops an app, or a farmer or rancher out in Amarillo or Midland hands off its product to an app store or to a national distributor of produce or beef, and out the door it goes. And then the app needs a patch, or the produce turns out to be tainted, and it has to be pulled back or fixed, right? That Texas small business or rancher who's never set foot outside the state is, on the state's theory, subject to personal jurisdiction in all the courts of this nation, at least any state where the product went. Because as soon as the product lands, and you send anything out, or you try to fix it in any way, including through intermediaries who are actually in the state and who are the proper defendants jurisdictionally, the state would say, well, you've reached out and touched the product, and so now you're on the hook.
But why aren't the facts here different in the sense that the German defendants controlled the distribution chain as well as the hardware that installed it on the end, which is, I mean, the app developer doesn't control the app store or the Android equivalent, and they don't have anything in the consumer's home that installs it.
So there is the evidence in the record contradicts both of those things. Well, it contradicts one and it's silent as to the other. There is no evidence in the record that they control the OTA system, that they developed it.
Would you have us believe that the German corporations just said, here's a modification, do with it as you please?
Oh, no, Justice. Everybody agrees, and I'm not here to dispute, that they developed the software update because federal law required that they try to fix the vehicles, and that's why they fixed it. But none of that conduct targets the state of Texas in the relevant sense. And the corporate representatives testified, and it was not disputed by the state, that there was no day-to-day operational control over VW America. It is a distinct legal entity. The state's never claimed alter ego or veil piercing.
Sure, but that's at a very general level. What we're talking about is the specific recall at issue here and what direction and control was exercised.
There is not evidence in the record, Justice Busby, and the state has not pointed to it in its briefs in this court or in the Court of Appeals, that they directed the recall. They have told the trial court the opposite. That is what the evidence in the record shows.
And
it's what the Court of Appeals got right.
There's contractual control over the recall in that it's VW America that should cause the dealerships or contractual enterprises, as they're termed, to perform those recalls. In other words, VW could require necessary recalls, but the agreement says that America shall carry out those recalls. But I think that Justice Busby is saying if the corporate entity, international corporate entity, directs the way that the intermediary carries out the recalls, that should be enough. Why isn't that right?
Because it might be, but it didn't happen here. Your reading of the contract is the right one. They could order the recall, but they couldn't order the way the recall was conducted. The way the recall was conducted was up to VW America, and it dealt with the dealers and the customers, not at VW Germany's instruction. And that's what the testimony in the record shows, and that's why the state in its briefs here and in its briefs in trial court has not come to this court saying, oh, they controlled the way that VW America did the recall. The kinds of things they pointed to in their briefs are, they gave a VIN list of the vehicles, they developed this proprietary system called Otis, and they reimbursed the dealers. They haven't focused on the way in which the recall was conducted because the evidence in the record shows it was conducted by VW America, not VW Germany. To go to one of your other questions, Justice Swain, and one of yours, Justice Huddle, is about Spearstar. I think this case just shows how you don't have any of the sorts of factors you had in those cases. In Spearstar, the company set up a Texas-specific distributor, came over and said, we want to target Texas. Didn't just hire somebody, set up its own Texas distributor, sent its officers over, had them in Houston, and cooked up the whole thing. Well, that's obviously targeting the state of Texas. That, I think, was a relatively simple case. But hiring a national distributor, that's Nicastro. McIntyre and Nicastro had a national distributor. It was exclusive. And its job was to sell as many of the machine shearers in the United States as it possibly could. And none of the 6 justices who found against personal jurisdiction there, and certainly the plurality, didn't pause on the fact of a distributor at all because it wasn't a New Jersey-specific distributor. And
Are you saying then that VW Germany and VW Audi would not care about how VW America conducted the recall, and if they decided, well, we're not going to touch the Texas cars just because it's our choice, that they wouldn't get any kind of pushback from VW Germany or VW or Audi Germany because they're the ones flipping the bill for it?
Look, I don't want to say that they wouldn't care in some relevant sense. Of course, reputation and goodwill and all the rest might be affected. But the question is, in terms of the independent entities, who made the decisions and who targeted Texas? Who actually came into Texas? Who dealt with the customers? Who dealt with the dealers? And here that was a separate legal entity, VW America. Did VW Germany have an interest in how their distributor acted? Well, of course. Every time you hire somebody or you use somebody to act on your behalf, you care how they comport themselves, or at least typically you do. But that's never been enough to give rise to personal jurisdiction. It's not the sort of thing a court is focused on when you have separate legal entities. The question is, were you directing and were you targeting the state of Texas? And here, the German respondents certainly had an interest in the United States as a whole. But if the state's right, they targeted all 50 states, and they could be held,
The our economic development department has a motto. I haven't seen it lately, but you may have. Texas, a whole other country. And that was a big advertising blitz for a while. If Texas were a whole other country, not one of the 49 states, and yet had all the same personal jurisdiction laws that we have pretty much adopted and following the U.S. Supreme Court, would your arguments be the same? So if they had targeted the 49 of the United States and also the country of Texas in the same way that they did, would your analysis be the same?
I understand that the state sometimes thinks of itself as its own country, and yes, Justice Boyd, the arguments would be the same. VW America would have targeted the country of Texas. It would have sold a bunch of cars there and then fixed them. But the German corporations wouldn't have targeted Texas. And you made exactly this point, in your opinion, in TVS Tecker for the court. You target a state. It's not a question of whether you target products of residents who happen to be in a place. The purposeful availment prong asks whether you targeted a state and took advantage of the benefits of being in the forum and hence have to endure the costs of being made to answer its laws. And here the German respondents didn't target Texas in any sense of that word. No property, no visits, no state-to-specific distributor, nothing of the kind of conduct that this court, other state courts, and federal courts have said matters for purposeful availment. They developed some software overseas and they handed it off to a national distributor along with a list of all the cars in the country that it was to be installed on. If that's enough, then as the state conceded last time, every aftermarket repair, update, or modification will mean personal jurisdiction in all 50 state courts. And they will mean it not just for German companies, it will mean it for every company or producer in the United States down to the smallest businesses in Texas. That's the theory.
What about Keaton, where there wasn't a state-specific distributor?
But in Keaton, Hustler was itself selling. Hustler's like VW America. It's putting the product into the state. Here, VW America takes titles to the cars in Europe and then warranties itself that it'll comply and sells them out to the dealerships here in the United States, which is why VW America has never contested jurisdiction. It was the original defendant here for quite some time. The state, I think, recognized it was the proper defendant, and it's never contested jurisdiction. This suit will go on against VW America regardless. And that's what makes the case so odd, is that they're in the trial court saying VW America should be held liable because it's done all the relevant conduct. They even use the word directed. It's not targeted, but it's as close as you get without, as synonyms go.
Well, why couldn't both of them be involved in a way that leads to specific jurisdiction over the German company, especially on a record where we have to assume that all facts were found in favor of the personal jurisdiction?
So, Justice Buzzy, let me take them in reverse order. If we were at the allegation stage, but we had a year of jurisdictional discovery, the state had every effort to prove up its allegations. So at that point, it's actually got to come forward and show that the German companies did something in Texas that would subject them to personal jurisdiction. And again, I think the Court of Appeals opinion couldn't be more thorough or well-reasoned on this point. It goes through all the evidence, including it disagrees with some of the state's assertions, and it walks through the record and explains what the companies did and what they didn't in a list of bullet points. And then it goes through paragraph by paragraph.
What state or country would have personal jurisdiction over the German companies for this conduct?
Oh, the United States, there's no question. It's at least the United States. They also, California, they haven't contested jurisdiction in California. They were sued.
Why is California any different from Texas?
So we explored this last time, Justice Busby. CARB, the regulator in California, which is differently situated from many other state regulators by virtue of the grandfathering and special California-specific provisions of the Clean Air Act, started investigating along with the EPA. The German corporations made a decision to come into California and to engage with CARB. So German officials came to California and engaged in a series of discussions and negotiations with the state. So they got sued there. They did not contest jurisdiction. And the only reason that Texas can't go sue in California or Virginia is because there is a state statute in the Water Code that says the case has to be venued in Texas. That's a really unique statute. I can't find anything else like it. Nothing would prevent the legislature from amending it. But I think the whole jurisdictional question only comes up here because this venue provision in the Water Code is like the tail wagging the dog. It keeps the state from going to sue anywhere else. And so now the state wants to change the usual jurisdictional rules and make Texas one of the most plaintiff-friendly jurisdictions in the country. Every time you have an update or recall, every plaintiff will come straight to Texas and say, you're subject to jurisdiction here.
Did the German companies engage in the same conduct with regard to vehicles in Mexico or Canada or any other country at this time as part of the same kind of effort?
Not that I'm aware of, Justice Boyd. I don't want to say that they haven't done other recalls in other countries.
Because it just seems to me if they had done the exact same thing through all of North America, North and South America, then the same problem would arise with regard to the United States. Well, they weren't targeting the United States, just fortuitously, some of the vehicles happen to be in the United States. So why doesn't that argument carry to the point to which there's no contact, no personal jurisdiction anywhere?
Yeah, so I take the point. I think at the sort of international level, you would still view them as distinct sovereigns, but the reason it would never come up, Justice Boyd, is that cars are designed to the regulatory requirements in a given country. The French cars don't look like the American cars, don't look like the Mexican cars, don't look like the Russian cars. Every country has its own state standards. So you're always going to have targeting at the national level in that sense because you're designing the cars for sales in that market. So I think it'd be very difficult to avoid federal jurisdiction for any of these large manufacturers, at least on claims similar to this one. And that's why the federal sovereign addressed this. That's what makes the case so odd, right? The federal sovereign punished this behavior to the tune of over $1 billion, 209 million of which has already come to the state of Texas and its residents for environmental remediation. I don't want to diminish Texas's interest in also trying to punish that behavior, but it's got to do it in accord with the usual jurisdictional rules. right? It can go to California, it can try to go to Virginia, it can try to go to Michigan where the software was tested, but it can't come into its own courts in Texas against not the national distributor that was here in Texas, but the German companies that had nothing to do with Texas and say, well, we can pull you in too. And then strain the contacts in a way that is really going to open up the jurisdictional analysis for Texas courts. And to your point, Mr. Chief Justice, yes, there were lots of VW cars at issue here, but there were only a few hundred Audis. And the state makes no differentiation based on the numbers, and it makes no differentiation based on the states. It's true whether it's a handful or thousands. It's going to be as true in Montana as in Texas. This is every product. It's every aftermarket modification. It's every state court in the nation. That's how broad the state's theory is.
Any other questions? Thank you, Mr. Wall. General, you have 5 minutes.
Thank you, Mr. Chief Justice. I'd like to start out with what I heard my friend on the other side talking about quite a bit during his response, which is the argument that Volkswagen Germany, the German respondent, somehow didn't direct or control the recall campaign in some way, and that there's, again, per his words, somehow no evidence in the record of that. I find that bizarre. Starting with, for example, the interrogatory on page 1447 of the first volume of the clerk's record, where Volkswagen Germany, and I'm quoting from the admission, Volkswagen Germany admits that it caused the software updates that included the tampering software to be installed in the vehicles referenced in Volkswagen Germany's response for request for admission. It goes on, if you'd like to look at a variety of portions, for example, of the importer agreement, Justice Bland. For example, the importer agreement, speaking directly to control, says all work and or repairs carried out, and this is in the recall context, shall be in accordance with Volkswagen VW AG's instructions, guidelines, and procedures. That's Article 16, paragraph E at page 1485 of the record. And page 1486, it says that recall and service actions will always be initiated by Volkswagen AG. It provides that the agreement...
So did VW Germany and VW America both direct and control? Because he says Friday you filed a reply brief, reply in support of your motion for summary judgment, saying that VW America directed and controlled.
So 2 points. First of all, it's agent and subagent, essentially. The control agreement between the two parties vested all control in the German respondents, and in turn, the American subsidiaries essentially followed exactly the directions they were given. This is on this record. It is a kind of curious form of asymmetrical judicial estoppel that apparently the statements made in ongoing litigation with the American subsidiaries, according to the German respondents, to be held against us, but I'm sure they wouldn't take the responsive concession back to the trial court. But putting that aside, it's very simple. They can be reconciled as that one controlled the intermediate and the intermediate controlled the dealerships, and that again is well developed in this record. Indeed, the agreement gives Volkswagen of Germany and correspondingly Audi of Germany the right literally to audit Volkswagen of America's warranty program and the repairs being made. It goes so far in terms of control to dictate the periodicity with which they can ask for reimbursements and the service codes they have to use in their, yes, Justice Busby, proprietary end technology that the German respondents controlled from front to back. So we're not just talking about control in the abstract or even control in the agent sense. We're talking a fine degree of control exercised from the beginning to the end of this process.
What do you say about the argument that we're opening up a floodgate of foreign developed recalls that would be subject to Texas jurisdiction if the product ends up in Texas?
I find that incredibly strange, Your Honor, for two reasons. First of all, going back to sort of the large 30,000-foot picture here, as the German response admitted in their essentially allocution in the Eastern District of Michigan, this was a once-in-a-generation grade fraud. We're talking about a series of corporate conduct.
So you're differentiating between a recall that's legit versus a recall that's fraudulent.
I think that's one of the components here. Of course, you have the extensive...
And why do you make that differentiation?
Well, in part, for example, the statements behind Nicastro and behind Guardian Royal that point out that such deliberate actions taken to flout a sovereign's laws might be, in Nicastro's words, sufficient for personal jurisdiction, or in Guardian Royal's merely enhance the minimum contacts. But of course, it's the level of control here that's most important. This kind of control, where it's extensively vested only in a foreign manufacturer who retains the power to dictate every term of the ongoing recall engagement, every term of reimbursement, and of how actually the recall is ongoing, and dictates the advertisement and distribution chains as well. That's an extraordinary and somewhat unusual great degree of control. Now, it might well be the case that if a foreign manufacturer engages in intentional torts tens of thousands of times in various jurisdictions across the country, knowingly flouting American laws and knowingly controlling advertising and distribution chains, that might be a problem for a handful of extraordinarily law disrespecting companies. But it's an unusual case, right? This is an incredibly unusual case.
So you're saying this is a very narrow exception that you're asking this court to make?
It's not an exception, Your Honor. This follows straightforwardly from Asahi's additional conduct standard, which this court has looked to.
But it applies to a very narrow subset, narrow facts.
Yes, Your Honor. This is the kind of environmental fraud that is thankfully incredibly rare. Most corporate actors are not so malicious and not so sort of brazenly disrespectful of both federal and state environmental laws. The idea that this will be such commonplace that it'll end up sort of damning Texas as a market strikes me as far-fetched. I see I've run out of time now.
Any other questions? Thank you, General. The case is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.